Jurisdiction of the Metropolitan Trial Courts, Municipal Trial Courts in cities, Municipal Trial Courts, and Municipal Circuit Trial Courts, or in short, the MTCs. The Municipal Trial Courts have exclusive original jurisdiction, first, in all civil actions and probate proceedings, testate and intestate, including the grant of provisional remedies in proper cases where the value of the personal property, estate, or amount of the demand does not exceed 300,000 pesos outside of Metro Manila or does not exceed 400,000 pesos in Metro Manila, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs, the amount of which must be specifically alleged. Provided that interest, damages of whatever kind, attorney's fees, litigation expenses, and costs shall be included in the determination of the filing fees. Provided further that where there are several claims or causes of actions between the same or different parties embodied in the same complaint, the amount of the demand shall be the totality of the claims in all the causes of action, irrespective of whether the causes of action arose out of the same or different transactions. So, we will discuss this totality rule in its specific part of this module. Next, the Municipal Trial Courts have exclusive original jurisdiction over actions in admiralty and maritime jurisdiction where the demand or claim does not exceed 300,000 pesos outside Metro Manila or does not exceed 400,000 pesos in Metro Manila. Next, the Municipal Trial Courts have exclusive original jurisdiction over cases of forcible entry and unlawful detainer, provided that when in such cases the defendant raises the questions of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership, the issue of ownership shall be resolved only to determine the issue of possession. Next, the Municipal Trial Courts shall have exclusive original jurisdiction over real actions where the assessed value of the property does not exceed 20,000 pesos outside Metro Manila or does not exceed 50,000 pesos in Metro Manila, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs, provided that in cases of land not declared for taxation purposes, the value of such property shall be determined by the assessed value of the adjacent lots. Next, the Municipal Trial Courts have exclusive original jurisdiction over all matters of inclusion and exclusion of voters from the list in their respective municipalities or cities under the Omnibus Election Code or BP Bilang 881. Next, the Municipal Trial Courts have exclusive original jurisdiction over cases falling under the revised rules of procedure for small claims cases. The Municipal Trial Courts have exclusive original jurisdiction over cases falling under the revised rule on summary procedure. Jurisdiction of Municipal Trial Courts in criminal cases. Except in cases falling within the exclusive original jurisdiction of the Regional Trial Courts and of the Sandigan Bayan, the MTCs shall exercise exclusive original jurisdiction over all violations of city or municipal ordinances committed within their respective territorial jurisdiction, and offenses punishable with imprisonment not exceeding 6 years, irrespective of the amount of fine, and regardless of other imposable accessory or other penalties, including the civil liability arising from such offenses or predicated thereon, irrespective of kind, nature, value, or amount thereof. The Municipal Trial Courts also have exclusive jurisdiction over offenses involving damage to property through criminal negligence, and where the only penalty provided for by law is a fine of not more than 4,000 pesos. the municipal trial courts have exclusive original jurisdiction over criminal cases covered by the revised rule on summary procedure. MTCs may be assigned by the Supreme Court to hear and determine cadastral or land registration cases covering lots where there is no controversy or opposition, or contested lots where the value of which does not exceed 100,000 pesos, such value to be ascertained by the affidavit of the claimant or by agreement of the respective claimants if there are more than one, or from the corresponding tax declaration of the real property. Okay, and then the decisions in these cases shall be appealable in the same manner as decisions of the regional trial courts. So it should be to the Court of Appeals. In the absence of all the RTC judges in a province or municipality, any MTC judge may hear and decide petitions for a writ of habeas corpus or applications for bail in criminal cases in the province or city where the absent regional trial judges sit. Assessed value must be alleged in real actions. Let us discuss the case of heirs of Orito versus Montes Claros, GR number 168935, March 13, 2013. The facts in this case are as follows. On January 1, 1997, the heirs of Gorgonio Sacro, or the petitioners, represented by Gorgonio Adobas, filed an action for reconveyance and declaration of nullity of deeds of sale, with prayer for accounting and damages against respondents the Montes Claros, Leonor Go, and Emiliana Che before the RTC. Okay? Petitioners, however, failed to allege in the complaint the current market value of the disputed properties, but attached instead the old tax declarations showing that the disputed properties had a total assessed value below 20,000 pesos. The respondents, upon being served with summons, filed their respective answers, all raising affirmative defenses and moving for the dismissal of the complaint. The RTC ruled by dismissing the complaint on the ground that the trial court lacked jurisdiction over the subject matter because there was no allegation that the assessed value exceeded 20,000 pesos. So the issue in this case is whether the dismissal of the case on the ground that there was no allegation of the assessed value of the property was proper. The court held that what is involved is a real action. That being settled, the next question is which court has jurisdiction when it comes to real action. Since RA 7691 was already in effect when petitioners filed their amended complaint dated January 15, 1997, then Section 33 of the law is applicable. Section 33(3) of the law provides for the jurisdiction of the MTC over real actions where the assessed value of the property or interest therein does not exceed 20,000 pesos outside Metro Manila or does not exceed 50,000 pesos in Metro Manila. The fact that petitioners failed to allege the assessed value of the subject properties in their complaint is fatal to its cause because this requirement is jurisdictional. It has been held that a complaint must allege the assessed value of the real property, subject of the complaint, or the interest thereon to determine which court has jurisdiction over the action. Jurisdiction over the subject matter is conferred by law and determined by the allegations in the complaint and the character of the relief sought, whether or not the party is entitled to all or some of the claims asserted. It does not depend upon the defenses set up in the answer, in the motion to dismiss, or in a motion for reconsideration. Thus, the fact that petitioners filed a manifestation declaring that the assessed value of said properties exceeded 20,000 pesos as shown by the attached new tax declarations, it does not cure the defect, okay? The rule is clear that what determines as to whether the court has jurisdiction are the allegations contained in the complaint. To reiterate, jurisdiction is based on the allegations in the initiatory pleading, and the defenses in the answer are deemed irrelevant and immaterial in its determination. Besides, the manifestations filed by the petitioners were only filed after their complaint was dismissed by the RTC for lack of jurisdiction, prescription, and for violation of the Katarungang Pambarangay Law. Action Publiciana and Reinvindicatoria. Let's discuss the case of Regalado versus De La Peña, GR number 202448, December 13, 2017. The facts of this case are as follows. Respondents averred in the complaint that they are registered owners of the subject properties and petitioner unlawfully deprived them of its possession. The issue in this case is which court has jurisdiction over the case, the RTC or the MTC. In the instant case, respondents only averred in the complaint that they are registered owners of the subject properties and petitioner unlawfully deprived them of its possession. They did not assert therein that they were dispossessed of the subject properties under the circumstances necessary to make a case of either forcible entry or unlawful detainer. Hence, in the absence of the required jurisdictional facts, the instant action is not one for ejectment. The complaint failed to specify the assessed value of the subject properties. Thus, it is now unclear if the RTC properly acquired jurisdiction or the MTC has jurisdiction over respondent's action. Next case, assessed value determined by the allegations in the complaint. Foronda Cristal versus Son, GR number 221815, November 29, 2017. The general rule is that the assessed value is determined by the allegations in the complaint. To determine the assessed value, which would in turn determine the court with appropriate jurisdiction, an examination of the allegations in the complaint is necessary. It is a Hornbook doctrine that the court should only look into the facts alleged in the complaint to determine whether a suit is within its jurisdiction. According to the case of Spouses Cruz versus Spouses Cruz, only these facts can be the basis of the court's competence to take cognizance of a case, and that one cannot advert to anything not set forth in the complaint, such as evidence adduced at the trial, to determine the nature of the action thereby initiated. Okay? It is not a surprise, therefore, that a failure to allege the assessed value of a real property in the complaint would result to a dismissal of the case. This is because, absent any allegation in the complaint of the assessed value of the property, it cannot be determined whether the RTC or the MTC has original and exclusive jurisdiction over the petitioner's action. Indeed, the courts cannot take judicial notice of the assessed or market value of the land. So that is the general rule, that assessed value is determined by the allegations in the complaint. However, there are exceptions. As citing Tumpag case, the court, through Justice Brion, provided for an instance when an exception to the strict application would be allowed. So in that case, the court held that generally, the court should only look into the facts alleged in the complaint to determine whether a suit is within its jurisdiction. There may be instances, however, when a rigid application of this rule may result in defeating substantial justice or in prejudice to a party's substantial right. In that case, there was also no allegation of the assessed value of the property. However, the court pointed out that the facts contained in the declaration of real property, which was attached to the complaint, could have facially resolved the question in jurisdiction and would have rendered the lengthy litigation on that very point unnecessary. Okay, in essence, the court said that the failure to allege the real property's assessed value in the complaint would not be fatal if, in the documents annexed to the complaint, an allegation of the assessed value could be found. The rule on determining the assessed value of a real property, insofar as the identification of the jurisdiction of the first and second level courts is concerned, would be two-tiered. First, the general rule is that jurisdiction is determined by the assessed value of the real property as alleged in the complaint. And second, the rule would be liberally applied if the assessed value of the property, while not alleged in the complaint, could still be identified through a facial examination of the documents already attached to the complaint. Indeed, it is by adopting this two-tiered rule that the court could dispense with a catena of cases specifically dealing with issues concerning jurisdiction over real properties. How about the alleged market value of property? In the same case of Foronda Cristal versus Son, the Supreme Court cited the case of Barangay Piapi, where the complaint did not allege the assessed value of the property. What it alleged was the market value thereof. The court held that in the absence of an allegation of assessed value in the complaint, the court shall consider the alleged market value to determine jurisdiction. Notably, the case referred to Section 7B of Rule 141 of the Rules of Court, which deals with legal fees to justify its reliance on the market value of the property. Okay, it said that the rule requires that the assessed value of the property, or if there is none, the estimated value thereof shall be alleged by the claimant. However, the rule originally contained in the sentence has already been deleted through an amendment by AM number 04-2-04-SC. What does this administrative matter provides? As it currently stands, Section 7 of Rule 141 of the Rules of Court reads that for clerks of regional trial courts, for filing an action for a permissive or compulsory counterclaim, cross-claim, or money claim against an estate not based on judgment, or for filing a third-party, fourth-party, etc. complaint, or a complaint in intervention, if the total sum claimed, inclusive of interest, penalties, surcharges, damages of whatever kind, and attorney's fees, litigation expenses and costs, and or, in cases involving property, the fair market value of the real property in litigation, stated in the current tax declaration or current zonal valuation of the Bureau of Internal Revenue, whichever is higher, or if there is none, the stated value of the property in litigation, or the value of the personal property in litigation as alleged by the claimant. But two things must be said of this. First, Rule 141 of the Rules of Court concerns the amount of the prescribed filing and docket fees, the payment of which bestows upon the courts the jurisdiction to entertain the pleadings to be filed. And second, the latest iteration of the same provision already deleted the phrase estimated value thereof, such that the determination of the amount of prescribed filing and docket fees are now based on the following: A, the fair market value of the real property in litigation, stated in the current tax declaration or current zonal valuation of the BIR, or B, the stated value of the real or personal property in litigation as alleged by the claimant. So in sum, a reading of the discourse in this would indicate that the jurisdiction referred to does not deal with the delineation of the jurisdictions of the first and second level courts, but with the acquisition of jurisdiction by the courts through the payment of the prescribed filing and docket fees. In the same case, the court cited the Trevilla case. This is the same tenor as the court's decision in that case, wherein no assessed value was likewise alleged in the complaint. The court determined jurisdiction by considering the actual amount by which the property was purchased and as written in the amended complaint. But then again, like the discussion in Barangay Piapi case, Trivilia case was one which dealt with the payment of the required filing and docket fees. The crux of the case was the acquisition of jurisdiction by payment of docket fees and not the delineation of the jurisdiction of the first and second level courts. In fact, the Trivilia case interchangeably used the terms assessed value and market value in a manner that does not even recognize a difference. Like Barangay Piapi, therefore, spouses Trivilia must not be read in the context of jurisdiction of first and second level courts as contemplated in the Judiciary Reorganization Act of 1980 as amended, where the assessed values of the properties are required. These cases must perforce be read in the context of the determination of the actual amount of the prescribed filing and docket fees provided for in Rule 141 of the Rules of Court. Okay, having laid out the essential rules in determining the jurisdiction of the first and second level courts for civil actions which involve title to or possession of real property or any interest therein, the court now shifts to the specific circumstances that surround the current case of Foronda. Okay, what are the facts in this case? In here, the respondent failed to allege in her complaint the assessed value of the subject property. Rather, what she included therein was an allegation of its market value amounting to 200,000 pesos. In the course of the trial, the petitioner asserted that the assessed value of the property as stated in the tax declaration was merely 1,030 pesos, and therefore, the RTC lacked jurisdiction. The issue in this case is whether or not the RTC should have dismissed the case for lack of jurisdiction, and in the affirmative, whether or not the RTC decision should be rendered void for being issued without jurisdiction. The Supreme Court held that, as discussed with the cited cases, settled is a requirement that the assessed value of the property must be alleged in the complaint. That the complaint in the present case did not aver the assessed value of the property is a violation of the law and generally would be dismissed because the court which would exercise jurisdiction over the case could not be identified. However, a liberal interpretation of this law, as provided in the Tumpag case, would necessitate an examination of the documents annexed to the complaint. So in this instance, the complaint referred to tax declaration number 164088 attached as Annex B, which naturally would contain the assessed value of the property. A perusal thereof would reveal that the property was valued at 2,826 pesos. So on this basis, it is clear that it is the MTC and not the RTC that has jurisdiction over the case. The RTC should have upheld its order dated November 8, 2006, which dismissed the same. Okay? Consequently, the decision that is rendered is null and void. So the Supreme Court went on by citing the case of Maslad versus Monson, where the court had occasion to rule that an order issued by a court declaring that it has original and exclusive jurisdiction over the subject matter of the case when under the law it has none cannot likewise be given effect. Okay, next topic. Assessed value is immaterial when the RTC is exercising its appellate jurisdiction. So in the case of heirs of Arrienda versus Calao, GR number 204314, April 6, 2016, the court held that it is true that under the prevailing law, in actions involving title to or possession of real property or any interest therein, there is a need to allege the assessed value of the real property subject of the action or the interest therein for purposes of determining which court has jurisdiction over the action. However, it must be clarified that this requirement applies only if these courts are in the exercise of their original jurisdiction. But in the present case, the RTC was exercising its appellate, not original jurisdiction when it took cognizance of Arrienda's appeal And Section 2 of BP 129 does not provide any amount or value of the subject property which would limit the RTC's exercise of its appellate jurisdiction over cases decided by first-level courts. Clearly then, in the instant case, contrary to the ruling of the Court of Appeals, the assessed value of the disputed lot is immaterial for purposes of the RTC's appellate jurisdiction. Indeed, all cases decided by the MTC are generally appealable to the RTC irrespective of the amount involved.